Hi, I'm Chris Colvin. I'm the founder of PARC and In the House, and those are two organizations for law partners and in-house counsel, respectively. I've been running those groups for about 10 years. Recently, we've been trying to bring those two groups together, as well as a third group, which is sort of the other vendors, legal technologists and others, because we really think, especially the pandemic has brought home the need for these three groups, which can sometimes be a little bit siloed, to really share information with each other and be more open in our communication. So that's sort of a big theme with us as we usually do a weekly program on Fridays at 3 p.m. Eastern. And we also add additional specialty programs some Thursdays. And so the next 4 Thursdays at noon Eastern, we're going to talk about legal budgeting, and especially from the GC's perspective, which is not only relevant to GCs, but obviously they're the firms that serve them, as well as the people that work for them, and the technologists that obviously in the past 15, 20 years have played a rapidly increasing role in litigations of all types and other legal matters as well. So I'm here with my partner in crime, Dave Stevens. I guess we're kind of like the Biggie and Tupac of small firm IP law. He has a firm out in Silicon Valley, and I'm a partner in a firm in New York. And we're also both sort of have a foot in the entrepreneurial world as well, and do work with our parts of startups and work with startups a lot. So I think we have a little bit of a 360 perspective on this issue. So we're going to kick off this 4-week series. So Dave, you want to tell the group a little more about your work before we get started with the presentation?
Yeah, I'd say I lean more toward Biggie than Tupac, but I'm working on it. So my practice is primarily patent prosecution. I'm in Silicon Valley. We also have an office in New York, but we do everything patents pretty much, and trademarks as well. We work with startup companies. We work with Fortune 10 companies, and we work very closely with a lot of VCs and other M&A activity in larger firms. We primarily work with firms who don't do what we do, and we work with startups and VCs that are not only protecting their IP, but also exploring opportunities and analyzing and auditing IP, which we'll talk a little bit about this week, but even more next week.
Excellent. Thanks so much, Dave. So let me get started with just the PowerPoint slides we prepared for you guys, and we'll just jump right into it. Again, we'll be running about 15, 20 minutes, we hope, and then we're going to leave plenty of time for Q&A. And we will turn off the recording at the end, so that no one feels like so we can have sort of an open discussion. So
to keep the questions coming in too as we talk, so don't be
absolutely
shy. We'll wait till the end.
Dave and I will feel free to, if you want to turn on your mic and ask a question out loud, that's great, or pop something in the chat window, and we'll try to keep our eye on that as well. So let's just go to the first slide here. All right. So just to make it a little bit fun, I'm going to throw out a movie quote and see if anyone knows who said it and what movie it's from. What we have here is a failure to communicate. Anybody recognize that? It's from an oldie but goodie. Yeah, Dave Slater?
Cool Hand Luke.
Yes, Paul Newman, Cool Hand Luke. Excellent. Okay,
Great movie.
You get the prize. Thank you. So I think that's a big theme, I think, when it comes to budgeting for complex matters and litigation in particular. I really think in my 26-year legal career, I've seen the need for way more communication. And so if you're talking about within the legal department, internally, I think the GC, the Chief Litigation Counsel, others that have litigation in their portfolios, they really need to make sure that they truly understand when they embark on a potential litigation matter, why, what is the underlying corporate objective here, and why do we either need to defend this litigation or bring this litigation, depending whether you're in the position of plaintiff or defendant, and really try to deeply understand that and keep that business objective or multiple objectives in mind throughout the life cycle, at the very beginning, all the way through trial and appeal if it goes that long. And then also really talk specifically about what is the range of budgets that make sense. Again, in-house counsel are really at their core risk managers. How do they make sure that ultimately there should be a business case for the litigation at the outset and at every stage along the way. So I think many legal departments do a good job at that, but that's always something to keep in mind. Another form of communication is with your peers at other companies. So I call it GC to GC, but obviously it could be other in-house counsel to other in-house counsel. And one thing I've definitely learned, I've used this tool a lot in my own practice, both when I've worked in-house as well as outside, is most likely whatever litigation matter you're facing, someone out there has faced a very similar situation. And you also find that sometimes it might be your first patent case. I mean, I've dealt with companies where they never had a patent case before, right? And so that's even more important. So don't reinvent the wheel. And I think people who don't use this tool regularly would be really surprised at how generous people can be. I mean, seriously, I have cold called GCs just that I found on Pacer and said, I see you got sued by so-and-so. Do you mind sharing? Obviously nothing confidential, nothing privileged, but would you be willing to do a call with me and my outside counsel about what you faced and size up the opponent? And people will be very generous because, the enemy of your enemy is your friend. That's a real thing. So, that make sure you use that tool, and you'd be surprised at how much information and value you can get. So Pacer's a great tool. There's other tools at the state level, but you can find out who has this firm sued, who has this company sued if you're on the defense side. And so you can do similar research if you're in the position of the plaintiff. Obviously, be careful. I always think, there's a little irony when people get nervous about things like this, in my view, because who better than lawyers to know where the lines are, right? You guys know how to not share privileged information. You know how to not ask for it. You can do this, right? That doesn't mean you have to stay in your silo and not communicate with your peers at other companies. So another really important category is the communication between the GCs and the outside counsel. And really work your network. When you're getting into a litigation mode, this is the perfect opportunity to reach out to lawyers you haven't talked to a while, whether they're at firms that you already work with or at other firms. And you can really get a lot of really valuable information. And I think outside counsel should be very willing to talk to anyone, whether there's a high likelihood that they'll become a client or whether it's just an opportunity to create a good impression and maybe be considered for later work. And certainly I've tried to be very generous with my time in those situations. I think Dave shares my view. So, squeeze all the juice you can out of every lemon. Why not? This is the time you have the leverage to get that information. It's really important to not accept don't let firms phone it in when they pitch you. Here's a picture of all our great lawyers. Here's all the amazing things we've done. That's all on their website, frankly. So you can get that from other sources. I think I'll be very frank, I think it's a complete waste of time for firms to run through their credentials in a meeting where they're being considered for litigation. So my view, and I think a lot of GCs and other in-house counsel share this view, is they should really be previewing their strategy for the case. One thing I try to think of is, I'm going to pretend I'm already hired, and I don't want to be presumptuous, but that's the way I could deliver the most value as outside counsel. Here's my initial thoughts based on the preliminary information you've given me. And I hope that's valuable. If you end up hiring me, great. If you don't, I hope you find it useful. And maybe some of these ideas could be put into place with the counsel you do hire. So really,
Chris, I would add to that too. I mean, the word you should be hearing primarily in those conversations is you. They should really be focusing on you. We understand what you need, right? And yeah, the beauty pageant is, I think, something of yesteryear, right? And it's really important for them to understand your business strategy, because ultimately, CEO, CFO, everybody's going to ask why we're doing this, right? And they better understand that as well. And to the GC communications, the GC to OC, work your network. You never know what you're going to find. I'll point out the obvious one is, if you're looking for a firm, look for one that's already beat this before. I mean, patent trolls are a really good example, right? I had a situation where there was a very big company that settled with a patent troll. I was representing another large company that was dealing with this patent troll, and business people talk to business people. We ended up getting an enormous amount of information that allowed us to knock them out. Because often when they're settling, you could have a total winning case, but you're settling it anyway. And it's not because you're losing it. It doesn't mean the company is going to lose, right? It just means they want to get out with a settlement. And if they've got information that can help you, for example, knock out patents or just ruin their case, they're often open to share that with you because companies are united, especially against something like patent trolls,
Right.
where they want to knock them out. So take advantage of that and don't just leave it to your outside counsel. They're not always that connected.
Right, absolutely. So, what I say sometimes is, hey, when you're choosing, say, between a general practice firm and a specialty firm, sometimes a Swiss Army knife is a great tool. I have, I think, 3 of them around my house in different places. But sometimes it's better to have a specialty tool, right? And so pick the right tool for the job, and really be clear about why you're choosing a firm. Not, it's great that you really do want to pick a firm you trust and you want to develop a relationship of trust, but you need to have that with multiple firms. And the way to develop that trust is to have a broad outreach initially and think, oh, well, that was an interesting firm. I'm not familiar enough with them right now to hire them, but I'm going to keep them in the running maybe for the next one. So you should be grooming those relationships with multiple firms I guess, in my view, and I think in Dave's view. So don't stop the communication when the lawsuit starts, right? That often happens because we're all busy, right? All outside counsel, in-house counsel, even our vendors like the e-discovery companies, everyone's busy, right? So you just start going and you crank up the litigation machine and you're running along the path, right? But I really think it's important to checkpoint. And these are procedures that I really think should be put into place in every major litigation, IP or otherwise. And have real performance reviews. How are we doing? I mean, it's sometimes hard to deliver, tough news to your outside counsel to say, look, you guys could have done this, that, or the other thing better. But, I think we all know, we're all grown-ups here, right? We all put on our big kid pants in the morning and we can take it, right? And it's better to know now if maybe we spent maybe the bill was a little too high, or maybe there was some other issue. Better to know now and fix it, right? So make sure you're open as possible in your communications. Also, check in on the business objective. Remember, we did that at the beginning. What are the business objectives? Are they still being met? Has somehow mission creep come into this and now the litigation is taking on a life of its own? It really shouldn't. Litigation should always be subservient to the company's business objectives. And by the way, if your outside counsel isn't asking you what business objective the litigation is serving, that's a trouble sign. They should know that, right? And if they don't ask, you should tell them anyway, but they really should be asking. I think the better practitioners these days, the ones that are more plugged in, are asking these types of questions. One thing I love in litigation is to have a binder. It sounds old school, but the 10 most important exhibits, the 10 most important witness statements, the 10 most important legal issues in the case. It could be very netted out. Now, 10's not a magic number, but I think your outside counsel should be able to answer that within 5 minutes. And if they can't, that's a problem, right? They need to be on top of the case. And there should, by the way, be one person who's really your contact. They should know these key exhibits. They have to say, oh yeah, that's the memo from such and such a date between X and Y. If they're not on top of it, talk to them. Say, look, I know you're busy. I know it's not your only case, but I expect you to have this stuff at your fingertips. And so whatever you need to do to make that happen, please do it.
There's great online stuff for that too, so that as it evolves, you can just, you have some like sharing type of documents, and they're very easy at your fingertips just to check in whenever you want to check in, because you'll forget and somebody asks questions, right?
Absolutely. And we're in this obviously long into the age of e-discovery. And I remember right at the beginning of my early, when suddenly there was this discovery this explosion in the number of documents we're dealing with. But you still need to separate the wheat from the chaff, and you need to have those kernels of important documents, both good and bad, right? So you might say, hey, what are the 5 best documents for our case? What are the 5 worst documents for our case? What are the best 5 deposition excerpts and the worst 5? And good litigators should have that stuff at their fingertips. Also, budget reviews, nip it in the bud. If the bills are creeping up and they're beyond the estimates, you got to call your outside counsel on that. Ideally, they're calling themselves on it. They're explaining it to you in advance, but no one wants a surprise, right? You don't want a surprise as the in-house lawyer. You don't want to surprise your client if you're outside counsel. And if you're the CFO, you really don't like those surprises, right? So this is important stuff. So try to build that into your process. So always checkpoint, what are we getting out of this case? Is it worth it? I really believe that the in-house lawyer should know every single lawyer on the case. So when you look at those invoices, you should know who everyone is. And then I'm including paralegals and even the outside contractors, like have a relationship with them. They're supposed to be providing value, and every single professional on the case should be providing value when they're billing time. Another really good tool that companies that I admire and legal departments I admire, they have a policy of trying to pick out the rising stars, and then it could be senior associate, it could be a younger partner. Find them and really start to groom them, because they're going to be really valuable to you. Those people do a lot of work. They're ambitious folks who are trying to either break into the partnership or build a book of business. They're going to work extra hard because they really want to make a name for themselves. So I talked about squeezing juice out of lemons. That's where you can get a ton of value. So try to find those people. I'm not dismissing at all the more senior people who bring tremendous value and tremendous experience, but you also want to identify those rising stars.
Yeah, it's a great point also, especially with cases of different risk or level of risk. I'm talking potential financial risk, is that you don't necessarily want to get the big firms to do it. I mean, often if you've got these patent trolls, you want to teach them a lesson, you want to keep hammering with the same people. But often the best way to fight, I use patent trolls as an example because that's a lot of what I do, dealing with that, is the best way to win. That's probably true with most cases, Chris. I mean, you can attest to this, is the best way to win a case is to outperform and underspend them.
Oh yeah, absolutely.
Yeah, especially with patent trolls, they're trying to build up there's this war chest to go after big companies, and if you beat them down and cost them,
oh yeah,
they're going to want to get out of there, chew their arm off and get away and let them, right?
Yeah, and it's true. And with those types of cases in particular, there's often multiple defendants. And I often think I'm never impolite to my opposing counsel, but I want them to groan every time they deal with me, because I'm going to give them a lot of work to do. They don't like to do work. And I'm going to make their life difficult substantively. And it'll be like a relief when they finally settle for a lot less, So I think keep that in mind. You don't want to be the easy defendant. You want to be the most challenging one in many cases.
And it's also referring back to your last slide and this one also, the banking industry learned that very quickly with a couple patent trolls, probably the last 2 years, is they completely ganged up on them.
Right.
And they drove them out of business. I mean, they successfully drove them out of business because the banks talk to each other. Hey, banks compete, but not there. They don't compete on technology.
Right.
It was a huge win.
Right. And in those multiple settlement contexts, another piece of advice I have, sort of standard for plaintiffs, and we're talking a little bit more on the defense side, but there's a lot of useful things that plaintiffs can do as well. But if you're the defendant and there's multiple defendants, don't just accept when they're like, well, we can't tell you about the earlier settlements, they're confidential. I don't buy that. I say, no, if you want to settle with me, I need to know the range. I need you to put in writing what the range of settlements has been on a per unit basis. And if you don't tell me, we're not settling. And you will eventually get that information. And I always like to say, all right, whatever, if it's a decent range that's acceptable to the client, I'll settle for the lowest one. You're not gonna get a penny more than that, but I'll match your lowest settlement figure. And you, again, being that pain in the neck and harder and more challenging to work with, not in a attitude way, but in a substantive way, that'll allow you to be down near that. It'll be a relief to take another lowball settlement from you. So keep those things in mind. One other thing I wanted to get to, I'll do another quote because I like to do these. Here's another quote. This is going to be harder, David Slater. So if you get this one, I'm going to be very impressed. All right, here's the quote. It's not a movie quote. It's from a writer, though. The future is already here. It's just not evenly distributed. Anyone know that one? It's a hard one. All right, no takers. Okay, it's very hard. I wouldn't have known it if I hadn't looked it up. It's William Gibson. He's a science fiction writer from like the 70s and 80s. And he's probably best known because his work inspired The Matrix. And I love this quote because it's very true, right? Like in the tech world, we think we have new things, but really it's existed in some form for many, many years. Like the iPhone, the basic guts of the iPhone existed in Xerox PARC, what, 20 years before the iPhone existed. So a lot of these things, it's about distribution. So applying that concept to the legal world, a lot of industries have done a lot of things for many, many years that we can use in our legal practices. And so here's some ideas that I recommend you think about if you're a GC or another in-house counsel with litigation in your portfolio. Think about RFT type processes, either a formal one or otherwise. There's a reason why it's standard operating procedure to do RFPs, in most industries, right? Because you get lots of information, you get lots of bidders, and you get a low price. But that's actually not the most valuable part of a process like an RFP. What you actually get are lots of ideas. You're squeezing juice out of multiple lemons and limes and making some, beautiful concoction out of it. So, push your bidders, right? Whether it's a formal bidder or someone in a more informal process, you really have a contest of ideas, not credentials, not the beauty contest like Dave said, right? So make sure you understand that and ask some questions. How are you going to handle the case? How are you going to keep this at a reasonable budget? So push and get lots of information. And when you don't hire someone, that's okay. Say, look, you provided, be courteous and gracious. You provided some really great ideas, and we're going to actually keep you in mind for future litigations. We're just going to go with a firm we've already used before for this case, but you're now going to be in the running because you really impressed us. So be encouraging about when people give you good information. All right.
Chris, I work with a lot of the RFP process with government too. And what's helpful is the more information you load into it, the more they have to work with. So once you've triaged your network and you've got more information, load all that up. Say, look, guys, I'm kind of doing your job for you. I'm showing you that you can do it more economically with this, right?
Absolutely.
More likely win, which litigators love wins, right?
Definitely. Great ideas. And one other thing I love about sort of RFP-like processes is, if you've got sort of, and no offense, but like fat and happy usual suspect firms that you hire all the time, they can be great. Look, you have a relationship of trust. I don't mean to diminish the importance of that, but they might budge on price a little bit more than usual if they know you're talking to other firms. And they're gonna be on their toes, and they're not gonna just phone it in either at the, the quote unquote pitch meeting, which is a word I don't like. I like to say, don't pitch where you eat, because you're trying to develop a book of business. Why are you pitching people? Nobody likes it, right? Talk about substance, talk about why, what do you bring to the table, not what you've done for the past, 20, 30 years. All right. Here's one that's still not done very often, but is done in lots and lots of industries. The accounting field, the consulting field, there's lots of situations where multiple firms work on a large matter. We don't do that much in legal. I think it's a huge mistake, with the exception of like local counsel, which is pretty standard. Other than that, we don't do this much. And I think it's a big miss for a lot of in-house lawyers. So it's a good way to sort of allocate risk, right? Like a situation that because I've been a partner at a big firm. I've also started my own practice, and I've been at mid-sized firms. And in all those situations, I think there's value that's brought for different reasons. And I think that, different levels of risk should determine which firms are hired, right? You don't want to hire the same firms for every case. I think is pretty obvious, but it often is still done. So I do think that a little bit of rivalry can be a good thing. Lawyers are good at dealing with adversity. We don't need to be snowflakes if we're not the only firm hired for a matter. And I think it's a good indicator if a firm's not playing nicely with a firm that's retained to help with the matter. That's a problem, and they need to be, take them to the woodshed a little and explain to them, like, you're going to have to work with this firm because this is the way we're going to do this thing. One thing I've learned is that it works better if you have a large firm and a small firm. I think two large firms, it can work. I've been on cases where it was two large firms and it did work, but it can be tricky because there's the egos are different. And also when you have a smaller firm, most firms aren't going to sort of try to, quote unquote, steal the client. If it's a big, huge matter, they may not have the resources to run a matter like that. but they have tremendous value to bring to the table. And like one thing I've done is when I've been at smaller firms is take, say, the 5 low risk depositions. You can probably do it for a third of the price of a big firm, right? And the witnesses probably aren't going to be called at trial, and you get a different perspective, and you can do it very affordably. And I think it's even the cost savings are great, but the even more important thing is having multiple perspectives on an issue. I think it can be very, very helpful. And then make sure that if you do this, right, it does complicate. And there's another variable involved. Have some kind of reporting structure where the GC isn't constantly sort of herding these cats. Hopefully the firms play nice with each other, but it's definitely something that's worth trying. And if anyone wants to talk to me about my experience doing this, I think it's a time it's an idea whose time has come, and I think you should really consider it.
Yeah, I'll add a war story to this if you don't mind, Chris. And
Yeah,
this is
absolutely.
It's actually a really good example too, because I'm getting calls. So we don't do litigation. We support firms that do, and we do triage when a client gets threatened, and we look at patents. We're an IP firm, so we look at patents and look at the threat. I've recently been called from GCs and also some other firms where they're calling me in to second guess to add value to really the prior art search, right? And often what happens is many litigators, nothing against them, but it's not what they do. They go and they fight this war. But what we do, and what many of the guys who work with them, men and women who work with me, they've been technical subject matter experts for many years. So you want to get this old codger who knows the technology really well, especially in the patent area, right, who knows the space, and they could dig down 20 years, 30 years back, stuff they even remember, right? Like pre-internet storage, right? And we've had several cases where we have found prior art that really knocks it out. The litigators sent out some project to a firm. They spent about $15,000. They said, okay, check mark. That's our search, and we're moving forward. Well, we went to work and we found some prior art that killed the patents, right? Yeah. So a general counsel can do that. And I'll tell you in one instance, we really butted heads. That firm was very offended that we were called in to try to help, right? Right. And our results spoke for themselves. But as a GC, you could be that mediator and say, listen, I'd really like to just do this, and I'm willing to spend the money. And yeah, I mean, it's really worth kind of putting your nose in there and politely, professionally saying, I want to do a little investment in killing this case. Right.
And by the way, it may sound crazy, but if you're an outside lawyer at a larger firm, you might sometimes want to call in your friends at a smaller firm because you may not otherwise get the matter, right? Think about co-bidding on cases, and I've done this. It's very interesting. You're like, look, a big firm can say, we might be a little costly for this, but we have a smaller firm we work with, and I think you're going to get at a minimum, you may not get the case, but at a minimum, your client's going to think, wow, that's some creative thinking. We should, let's think about that in the future. So, is it somewhat of a risk? Maybe, but if you're not going to get the matter at full freight, instead of discounting and hurting your own firm, and it's much better to bring on somebody else. So I think we need to be a little more creative. So we had a question from Andrew. So he says, on multiple firms for large matters, how about cost efficiencies for multi-jurisdictional matters when you have to hire multiple local counsel? So Dave, you want to take that one, and then I'll add whatever else I have on top of it.
Right. Well, local counsel should be relatively inexpensive. I mean, that's not a real high cost thing, even in big jurisdictions like New York and LA. So you're going to need them anyway, right? You can't really cheapen it. There's no central way to do it. But what you want to do is make sure that the big firm is doing the heavy lifting. Don't offload a lot of legal research on them necessarily, right? And they should be really there for the procedural matters. And that's how you keep the cost down.
Yeah, and when you get to trial, one thing I would add to that is when you do get to trial, and I think you should think about this when you hire a local counsel, you really want people that are plugged in, like the judges know them and respect them. They've got to, I mean, let's be frank, if it's in Texas, it doesn't hurt to have an accent, right? Maybe they wear a cowboy hat around the courthouse. Seriously,
you related to the judge, yeah.
So it's like it matters, right? So make sure if you can, I think I often think local counsel are undervalued more than they should be. They provide tremendous value. And by the way, don't sideline them at trial. They should have a prominent role at trial. Because I know I'm in New York, so this happens a lot where I have local counsel in some somewhat smaller or different jurisdiction. You don't want a bunch of New Yorkers riding into town and running the show. It needs to be a true partnership at trial. And so don't. So you may not need your local counsel too much. Maybe they're more of a mail drop for the first 9/10 of the case. But when it comes to hearings, when it comes to trial, they're very important, I think. So I don't know if that helps, Andrew, but I think that's, I definitely think it's an important resource, but you don't skimp on local counsel. So I would
especially the relationships with clerks. I mean, often what happens is not in front of the judge, right? I mean, somebody who can grease the wheels in the clerk's office or just, get a fair shake. Nobody like a local counsel. Right.
Yeah, I mean, I'll just tell a brief war story. We had a giant case in the District of New Jersey, and now I'm a parent of teenagers, but at the time I was parents of toddlers, twins, and I was like passing around the baby pictures with the court reporter and the clerk, and the judge wasn't around, but I mean, I didn't do it. It wasn't like a shameless attempt at getting sympathy. It just was, we were chatting, and I was like, I had the little, it wasn't even on my phone. It was a little tiny, and they were looking at them. And I mean, that really helped. It was like, suddenly I was a person and not just this pain in the neck lawyer. So you never
want to humanize all of those relationships, humanize them. You're not going to stuff up to the judge, but these other people, they have lives, they have boring jobs. And the nicer you are to them, the better off you are.
And the court reporter, by the way, don't ignore the court reporter either at the deposition or at trial, because at trial, the judge knows them, right? They have a relationship.
Right.
And the magistrate judge, if you have a magistrate judge in your case, they all know. And really, sometimes the court reporter has been there longer than the judge, right? Like I had in that District of New Jersey case, the court reporter was probably 70 and he had been around forever. Like he was a eminent figure in that courthouse and he was a great guy, and it was so painless and a joy to deal with him. So be nice to the court reporters and the staff. Definitely a good, thank you, Dave. I'm glad you mentioned that. So I think
it also happens at jury trials. I know you're referring to this too, but to be really clear, like if you're down in Texas and you're a New York firm, this city slicker comes in and talks to the jury. It's often nice to have a more soft-spoken Texan at your table saying a few words, just to calm that kind of bias. Right?
Yeah, and by the way, it doesn't have to be that distant. I mean, I'm based in New York. Even if you're in New Jersey or Connecticut or Delaware, New York's not local enough. I'm sorry, New Yorkers, but that's not local enough. You want a Jersey person or a Connecticut person or a Delaware person, even though we think about like our tri-state areas in different parts of the country, but that's not close enough, right? So anyway, hopefully that was helpful, Andrew. And that was our thoughts on that issue. Let me just go to the next slide. So I think, Dave, you were going to go a little bit into cutting costs and the importance of that as you go through the litigation process.
Yeah, well, so audits are something, I think it's a term that's underused in the legal practice in general. I mean, when you're revamping, I shouldn't say revamping, but now's the time of year where you're looking at budgets. You're looking past at the year, the changes are made in January. But you could do this anytime, is to do this audit, and you don't have to spend a lot of time on it. Have a good reporting structure that makes it easy throughout the year. And maybe that is part of the audit, is to get yourself more informed better about everything, including budgets, so that you can easily audit things, right? Look at the different cases, look at the different firms that you've hired. In our area, it's so easy for the project creep to get out there. Because legal, they supervise things, ongoing things, even insurance matters, for patent prosecution and trademarks and things like that. Often there's this trust factor, it goes off somewhere else, and you think it's pretty well compartmentalized. Well, everything can be optimized. If COVID taught us anything, is that any budget can get optimized. Like when you have no budget, right? and you'd be amazed at how efficient a law firm can get when they see their client in trouble who has always been a great paying client, and they'll be a future great paying client, but they're having a hard time now. I run into them all the time, but especially through COVID. And if you can help this outside counsel be the hero and help you, it richens your relationship, and it really helps you solve that internal problem. Constantly cutting back costs. Look at fixed costs. There's always ways to optimize things. Just revisiting things and just asking these questions. And also just letting them know that you're looking at the invoices. And one of my clients showed me probably the most polite way to do it is that no matter what invoice comes in, he would look and just, ask questions, even about a tiny out-of-pocket expense. Just letting them know that you're looking at every line of that invoice and not just forwarding it to finance. And when you do that, they'll think twice before they, put in a charge that I'm not saying is questionable, but maybe they spent too much time on it. Maybe it's something that's not appropriate for an invoice. Letting them know that you're watching. Legal invoices and things like that. I mean, we all have experience reviewing them and things, but it's often good to have conversations about these, because what I'm seeing now is I'm seeing a lot of, I speak to CFO groups and CEO groups, and they're starting to question all of these because the budgets have really dropped. They're trying to maintain these legal budgets. They think they need them. They need them for risk assessment and administration, but they're constantly questioning it. And you may as well address this now before they do, because nobody does it like the finance industry, right? They learned early on how to get optimized, and there are many ways, new ways that legal departments can really, maintain your relationships, meet all your goals, but at the same time, you can optimize things and cut costs and keep everybody happy.
Yeah,
We talked about outsourcing.
Can I double down on the admin
Please.
cost of the out of pocket? Because I agree with that, and having talked about legal invoices many times over the years from both sides, it's sometimes those costs, the out of pocket costs, that really catch the reviewer's eyes, whether that's sort of someone in-house or sometimes it's an admin person at the client that does it. But those sort of jump out at you, right? Like, if spending 10 hours instead of 8 hours preparing for a deposition, it doesn't doesn't like hit you in the gut quite the same way as saying, well, wait, why did I pay for 6 dinners last month, late one night, and then 6 town cars home from the office, right? And so I remember, even when I was a partner at a big firm, I usually would not do that whole jump on that seamless bandwagon and order a ton of sushi and order the black town car. I'd say, you know what, I'm just take the subway home. There's going to be good leftovers in the fridge. And I think clients really do appreciate that, and they notice it, right? And because it's more obvious. So if you're outside, don't forget that stuff. That matters to clients. And if you're a client, it's okay to call people on that. Like, did you really, why are people doing work late at night and taking town cars all over the place? Especially now, right? Now you could say, well, they probably could have done a lot of this doc review from home. So I don't want to go too overboard on that point, but it is an important one.
This other client of mine, one thing that it was a nice personal touch dealing with outside counsel was they would go out to lunch and they'd pick it up. And so he's speaking with all these attorneys. They're not going to bill for that time if you're buying them lunch, right? Make it a nice 2-hour lunch, and there's nothing sinister there. You want to connect with them, and you really want to connect with them. Yeah. So you get so much done at that one sitting. You'll get the updates you want. You'll get the questions. You'll have everybody in the same room. You buy them lunch. Everybody's full of food, which makes everybody happy. And they're okay not billing that time because they're happy. They're full, right? Yeah. And it's a great way to do that. Once a month, if it's a litigation, especially, you want to get in there and check in and let them know that there's a human being there, albeit a representative of the company, and you connect with them, and they just stay more honest, frankly.
Yeah, that's money way better spent taking the lead lawyer out for a meal than paying for 6 associates to order.
Take them all out. Take them all out.
Exactly. Great points, Dave. Sorry, I didn't mean to break your flow.
No, that's all right. It's all right. Yeah, outsourcing. We talked earlier about having other experts kind of chime in. I mean, you can learn so much by talking to the other outside counsel and other general counsels. There's a lot of technical experts out there. There's usually very few of them in any one specific space. And you get this older person who's seen everything, and often they can really add a ton of value, given more background on the subject matter of the case outside, this legal process and litigation. And you'd be surprised at what you can learn, because you often don't have that internally to the company. You just have the people that you have.
So let me go to the next slide, but we also have a question from David Slater. Are there benchmarks for what a company should be spending on all legal fees as a percentage of their overall budget, e.g. 3 to 5% of total operating expenses, I think is the question. So Dave, any thoughts on that? I'm going to go, and anyone else, by the way. So I'm not aware of those benchmarks, but they may exist.
Well, I think it would also vary widely if you're talking about even different types of litigation. If it's insurance litigation, which is extremely optimized, right?
Right.
Or if you're talking other civil litigation, patent litigation, you can, I don't know if there's a benchmark that you can look up, but you can get a good idea of it if you look at your network. I mean, really, that's where you find that, because it changes all the time.
Right.
But for the most part, well, patents are really interesting because there is this kind of set value of expectations, the outcome, because it hits revenue, and you can do those calculations. You can have many litigations, but I think that's how you would calculate it. But I think if you looked at different areas, you really need to explore them separately because they're very different.
Yeah, definitely. And someone helpfully shared that they're held to 2.7% of their company profits for all legal spend. So that's at least one data point. I would recommend, to Dave's point, and going back to what we covered right at the beginning of the discussion, call your peers. Similar cases, similar companies. What are they spending? They may not want to share the exact amount, but they'll give you some ballpark figures and share. So take, at least once you feel safe doing so in the COVID era, take your colleague out for a drink and sort of, it's okay to ask them, look, I want to make sure I'm not overspending here. So that's the best information, is the one-on-one sort of discussion with your peers. It's an invaluable source. So Dave, you also want to cover, I think our last point is careful about cutting expenses too much.
Yeah, well, it's also, Tara's question also spawned something from this same slide, being careful where you cut, but you want to be aggressive where you can cut. And I've seen where, it's a very MBA thing to step in there and talk about percentages. I'm not saying that Tara's approach is wrong, but often I've seen that we're like, look, we can justify $3 million spending on all this stuff, when if you really look at what you're spending it on and why, developing trademark assets, patent assets, or copyright, whatever you're protecting, you can often do it for a fraction of the cost. So while it's good to have a ceiling, often I've seen outside vendors, some of them are specialists, where they try to justify this high spend based on your R&D, but not laying out the purpose for the specific thing that they're doing. So you really want both, knock that from 2.7 to 1.2 if you can. Especially now.
Definitely. So I'm looking at the clock and we're running a bit over on what we thought we'd be, but we did get some questions. So let me just advance a little bit and keep things moving here.
Sure.
So we just have our closing slide, and maybe we'll cover these really quickly. One thing I say a lot is that, GCs, you're on the buy side of the legal profession. That's a deliberate nod to the financial services field, right? The buy side is the boss, the hedge funds, the private equity firms. They're the ones purchasing the services, right? And purchasing the equity. So think of yourself like that, right? You have a portfolio of matters, and you're in charge. That the partner handling the matter for your outside counsel is not the boss. You always are the boss. And I think so you have the right to know what's going on in those matters. Just like a private equity firm has the right to ask the C-suite of its portfolio companies, hey, what's going on? That was some bad news I saw in the Wall Street Journal. You should be on the ball and keeping track of what's happening in your matter. So that's a really important one. A lot of these are reviews, so I'll just hit them quickly. Just keep your mind on the corporate objectives underlying. Always, you're the risk manager. Always balance the risks and costs throughout every stage of any major matter, especially litigation matters, which can be costly. Be a smart consumer, right? not every Swiss Army knife is great, but it's not the best tool for every job. So pick the right tool for the job and constantly reevaluate that. Think about real genuine partnerships of mutual trust at all levels, right? Not just the attorney level, but the staff level of your firms, and at the courthouse, as Dave mentioned, and with your vendors, right? You can learn a lot from your court reporters and your e-discovery firms. And if you use an expert advisory firm or independent experts, you can learn a ton from them. And by the way, same rule that Dave applied, take your expert out to dinner and pay for them, and you'll get a lot of free information, right? So don't think about, think a little outside the box for these. Be aware of the latest methods to optimize legal spend. New things are always coming on board. I saw someone posted about online billing systems. We have a sponsor at PARC who's in that field. There's there's some very good tools that you can use to help keep your legal spend under control. I guess, like, apologies to Chicago, but like voting early and often in Chicago, revisit your litigation plan often. Go over it with your legal team internally. If you're in-house, go review it with your bosses, right? Or your colleagues in the C-suite, so they know what's going on. You don't want that CFO to notice the litigation just because one legal bill is way out of whack and too high. And also your outside counsel. So that's really everything. I want to give Dave a chance to provide any last comments, but also I think we put our contact information there. So if you want to reach out to Dave or to me, we're happy to have a follow-up discussion. And as a last reminder, this is the first of 4 weekly sessions on Thursdays at noon Eastern. So Dave, any last thoughts? And then I'll turn off the recording and we can take Q&A in the remaining minutes.
Yeah, again, emphasizing the point you made that you're on the buy side and it's you, especially when you're hiring a new firm, right? I mean, once the ball gets rolling, it's difficult to roll back and say, can we cut back on certain costs? When you're hiring somebody new, that's the time to ask for a break, understanding that over the next year or two, that there's always increases, and share that and let them know that you're okay with that. But if you start with the lower end, let it increase a little bit over the year. On average, you're saving money, and immediately you're a hero at your company, right? So everybody's happy there.
Perfect. Thanks so much, Dave. Great session. Sorry we went a little longer than we had anticipated, but we are going to stay. Dave, I don't have anything right after this. Can you stay a little bit longer if people have questions?
Oh, yeah. Happy to take questions. Sure.
Cool. So I'm going to stop the recording. If you want to know about PARC, you can go to PARC with a C, parclegal.org. And you can always find me. Best email address for me is, our parent company is In the House LLC. So chris@inthehouse.org. So I'm going to stop the recording, and then we'll have a little bit of an after party and Q&A session for anybody that wants to say. Thanks again, Dave. Great information today.
Oh, you too. No, it was wonderful.